AMF and the Texas Accountants and Lawyers for the Arts, in partnership with the Copyright Alliance, are excited to present tonight's seminar, Creativity Meets Copyright, Owning Your Art. A special thanks to Emos and C3 Presents for providing this space, and Texas Commission of the Arts for partnering with us as well. We also want to thank the Cultural Arts Division of the City of Austin for their support. We are pleased to welcome our presenters, Andrea Villarreal of Counsel at Hartline and Daly, LLP, and Gwen Seal, Associate at Mike Tollison and Associates. Thank you so much, and I will pass it on to these ladies.
I'm Andrea Villarreal. I'm of counsel at Oaks, Hartline, and Daly, like she mentioned. I've been practicing law here in Austin for 8 years now, and I'm honored to be here. Thank you.
Hi, everyone. I'm Gwen Seal. I'm with Mike Tollison and Associates, and I've been practicing with Mike for a little over 2 years now. So thank you, and let's get started. So why is intellectual property important to you as artists? Well, just like we have laws that protect our personal property and real property, we have laws that protect the fruits of our artistic endeavors. IP law is the foundation that protects your brand, so like your band name, for example, and it protects your original works. IP law fosters innovation by allowing for owners and controllers of works to be able to go out and exploit those works, and also gives the ability for those owners and controllers to be able to earn income from their works. Also, too, IP law helps to demonstrate ownership of your works, and it helps to protect against theft or unauthorized uses of your works.
And one thing that's really important to remember is, just like you have pieces of artwork that are really valuable, a physical piece of artwork, a Picasso or something that you purchase, music is also intellectual property that can be passed down from generation to generation. So that's something else, there is value in that.
Yeah,
and
definitely.
That's going to be a recurring theme.
So there are 4 main types of intellectual property, the first being patent. And so patent protects inventions and it protects processes. Then there's trade secret, and trade secret protects Oh, okay. Trade secret protects inventions, and it also protects formulas. Think, for example, Coca-Cola, their recipe, that would be a trade secret. Then we have trademark and copyright. And one thing that I've noticed, and I'm sure Andrea has as well, a lot of people will blur the lines between these 2 separate areas of IP and will use the term copyright and trademark interchangeably, which is wrong, and you definitely should not do that. Trademark serves to exclusively identify a good or a service with a specific brand. And you have trademarks under that trademark umbrella, and trademarks apply to the providing of goods. So think, for example, Nike. Nike provides clothing, shoes, accessories, goods, and the word mark being Nike spelled out, and the design mark or the logo, so the Nike check mark, those are trademarks. Now, when it comes to you as artists or being part of a band, and you providing the service of going out and performing live, your band name, so either the word or your logo, if you have one, those are service marks that are protected by trademark.
One thing I like to think about with trademarks is it's really a consumer protection area of the law. So the purpose of a trademark is to make sure that consumers know that if something has that Nike swoosh on it, that the quality of the goods is going to be of a certain caliber. And the same with a band name. So Rolling Stones, there's only one Rolling Stones, right? And you associate them with being very successful. If another band were to start touring as the Rolling Stones, first off, they would very quickly get a cease and desist letter from the Rolling Stones, but also that would be something that that would impede on their on the caliber of their brand. If you accidentally, basically, if you went to go see the fake Rolling Stones, you would be very disappointed if, as a consumer, you spent a lot of money thinking that you're going to see the Rolling Stones. So it's a consumer protection area of the law, and that's one thing that helps for me to differentiate between copyright and trademark.
And so copyright protects original works of authorship fixed in a tangible medium of expression. And so at the most basic level, think trademark, brands, copyright, your works. There's that distinction there. So we're going to go over a brief history of copyright law really quickly. There are two main sources of copyright law. You have the U.S. Constitution, Article 1, Section 8, Clause 8, and you can read the text down there. And then from there, we have the Copyright Act of 1976, which is our primary source of copyright law. And the Copyright Act of 76 ended up amending the 1909 Act, and since 76 we've had some additions to the Copyright Act, like the Digital Millennium Copyright Act, which essentially brought a very, very old compilation of laws into the digital age. And then we have the Music Modernization Act, which I'm sure a lot of you have heard of. We're not going to talk about it tonight. That would be a whole separate presentation because there's a lot to go over regarding that. But yeah, so that is kind of a brief history there.
It's hopefully a changing body of law, because if you look at the copyright law as it exists now, there are definitely some updates that need to be made, and those are the Music Modernization Act is one of the things trying to get those updates in place.
Exactly. So next we're going to go into some copyright basics, like what can be copyrighted. Works that are those of original authorship can be copyrighted. So I couldn't just go and copy something that Andrea has written and say, that's my copyright, because it's not original, it's hers. I copied it. The work has to be creative in nature. Granted, the scope of creativity is it has a very low threshold to it. What is creative? I mean, it's very subjective. And it has to be fixed in a tangible medium of expression. And we will go into that definition in a couple of slides. And that definition has been developed on account of case law. So there are quite a few types of original works of authorship. We have literary works, musical works, including any accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, architectural works, and sound recordings. And although Andrea will be going into this in just a few minutes, I think it's really important to hammer this point home that when it comes to a song, there are two copyrights involved. There is point 2, musical works including any accompanying words, which is a musical composition. And then you have the sound recording, which is a recording of a particular musical composition. So if you don't take home anything else today, I hope you do. Just at least take home that when it comes to a song, there are two separate, distinct copyrights.
And another word for the sound recording copyright is the master. So
yeah. So what does fixed mean? So once you've jotted something down, at that point, it's fixed. So you've written something down on a piece of paper, or you've typed something up and saved it in Microsoft Word, or you have captured a photograph, or you've taken some clay and molded it into a sculpture. At the point where you have once you have something actually fixed out there that's in a tangible form, at that point, your work is fixed.
arguably even a voice memo on your iPhone.
Yeah.
Of a song, something that you sang into it while you were, out of the shower, probably not in the shower, but, you thought of it in the shower and then you recorded it afterwards. So,
Exactly. Also keep in mind that ideas are not copyrightable, but once you jot down that idea, once you put it in some sort of tangible form, at that point it's copyrightable.
Right.
As a copyright owner, you are afforded certain exclusive rights when it comes to your works. You have the right to reproduce copies of your works. You have the right to distribute your works to others, the right to perform your works publicly, the right to transmit sound recordings digitally, and the right to prepare derivative works.
And to display publicly.
And to display your works publicly. Keep in mind that if anyone ends up trying to take these rights away from you, it's infringement. Because these are your exclusive rights, meaning they are yours unless you transfer them to another party by writing, usually. So let's get into derivative works. A derivative work is a work that is based upon or incorporates one or more pre-existing works. And so that would mean the work that you're using is going to end up being transformed or adapted or recast in a certain way. Also keep in mind that the changes that you make to the work have to be substantial, and you can't just make a couple of minor changes here and there and it be a derivative work. So let's say, for example, Andre and I are songwriters and we have a band, and our band is called The Legals. And we are writing some songs together, and we've written one particular song, but a month later we decide, I kind of want to change up this particular lyric here or this note here. Those changes wouldn't really amount to a derivative work because it's not really substantial and we haven't added much in the way of new material. Right. Now, if we go in and rearrange that particular song, at that point, that would be a derivative work of our original work. And what's kind of going on from that, some examples of derivative works are translations, arrangements, dramatizations, adaptations, or let's say you want to take a book and create a motion picture based on that book. That would be a derivative work. And one thing that I think would probably apply to a lot of you as artists, sampling. Yeah. Sampling a work would be a derivative work. Also, if you are going to be creating a derivative work based on some work that you do not own, you need to ask permission to do so. And the owner of that original work doesn't have to give you permission in order for you to use that work.
So, again, we're going to hammer home this point over and over and over again today. And if you don't take home anything else, please take this home. So, copyright in music. In every song that you hear on the radio, anywhere, there are two copyrights in that song. There is one, the musical composition, which, the music, the lyrics and the melody. The way I like to think of it is the intangible copyright, the thing that you came up with in your head, the thing that you can hum, that's the musical composition copyright. And then the second one is the sound recording copyright, or the master recording, which most people in most contracts will refer to it as. And that, the way I think about it, is the physical embodiment of that musical composition. So you have that intangible thought, that song that comes to you, and then once you put it into a physical form, you record it. That is the sound recording copyright. Does that make sense? All right, cool. So who owns a copyright? The creator, the person who made the work, or multiple creators, a band that wrote the songs together, or a group of friends that wrote the songs together, multiple people who made the work together that owned it, who decided to own it either equally or unequally, and we'll get into that in a minute. An employer or a commissioner of a work. So you might have heard of works made for hire. If you are employed by let's say a publishing company or something, you're employed by them to write music, then in the scope of your employment with this company, anything you write belongs to them. That is a work made for hire. It came about a long time ago, I remember reading, I'm a total classical music nerd, In a long time ago, it would be somebody noble who would commission a work of art, a song or something for a particular event. And that was a work made for hire that would actually belong to the royal or the noble who commissioned it. That's where that comes from. Another person who could possibly own a copyright is an assignee. And what that means is that the original owner of the copyright transferred their ownership in the copyright to somebody else who is called an assignee. The person who has transferred the copyright or contract, by contract or by will. So again, I mentioned before, a copyright is a piece of property that you can pass down to other people. If you left it to someone in the will, that would be that person. They're not the original author, but they got transferred it by some legal document. So a joint work is created by two or more people with the intent that their contributions be merged into inseparable or independent parts of a unitary whole. A band, that's, you guys are all jamming and come up with something, and it becomes a song eventually. That is something that you intended to merge together to become one work. You're automatically considered joint authors unless there is some kind of contract stating otherwise. This could happen, for instance, if somebody is recording music, you've got a singer-songwriter working with a producer in the studio. And then you get some session musicians in, and the session musicians sign a contract that says any contributions that I might make to this, or any horn licks that I put into this, are considered works made for hire, or that they belong to the singer-songwriter, the artist, and they sign over a document saying, I transfer any ownership I might have to the singer-songwriter who is paying me for my contribution to this music. That's something that would be stating otherwise. You're deemed to have equal ownership even if one person contributed more to the work than the others. So you, as a band, if the guitar player, who's also the lead singer, comes in with, with the main portions of the song and just needs, everyone else fills in, a bass line, the drum part, and maybe a bridge or something. The singer and lead guitar player might say, well, I contributed more to the creation of this song. But if there is not any kind of contract in place saying he's going to get 60%, the rest of us are going to get, 20, it's deemed to be that everyone contributed equally. Which brings us to our next point, that the wisest choice is to create a contract to make sure that the intentions of everyone are clear.
Yeah, and to piggyback off that point, if you are in the writing process, you need to use split sheets.
Yes.
I can't begin to tell you how many times we've had people come into our office and say, well, I played drums or I played guitar on this song, so I wrote the song. That's not necessarily correct.
Right.
Just because you played on a sound recording does not mean that you are someone who participated in the writing process. Maybe you did, but maybe you also didn't. It's also hard, too, when you have situations in which maybe a band member leaves or gets kicked out of the band and there's nothing in writing, because at that point, everyone is upset at one another, or maybe they're not, but a lot of times they are. And what would save a lot of heartache and headache is by, when you're in the writing process, executing split sheets. And so these split sheets would identify each songwriter's ownership of the particular compositions, and it should also lay out what the songwriter contributed to, whether it's writing some of the lyrics or the melody or both. So please do that, because it will save you a lot of headache later on and will help spare everyone from being confused. And I imagine you could probably Google split sheets and you might be able to find some forms there, or at least some ideas to get started on.
Yeah. And I mean, most of the time, a split sheet is just a page long. So you could hire an attorney just to draft up one that will work for you, depending on what your circumstances. If you're, we represent some studio owners, and I've made for each of these studio owners a split sheet that they've got there, so that as part of their service to the musicians who are recording with them, you can use this to make sure that the people that we're bringing in, the studio musicians, everything's clear. That's something that I find really, really helpful, because it's so much easier to make a contract and come up with these splits when everyone is happy with one another and they're all in the creative process and they're all excited about the song that they're creating, rather than when everyone's pissed at each other.
Exactly. And there are situations, too, where you're in the studio and maybe a producer is helping with the songwriting process. And so in that case, you would add the producer to the split sheet and then at that point determine what each person's percentages should be. And everyone needs to sign the split sheet, because it won't be very helpful if you just have a piece of paper saying everyone's percentages and no one signed off on it.
And that's another really good point to bring up with respect to producers. If you've got a producer agreement that the producer has you sign, you want to look to see if in that producer agreement it says anything about musical compositions, whether or not the producer is expecting to be, to get any of the musical composition copyright. Because a good producer, realistically, a producer who is producing is going to make some tweaks to your song, going to suggest some arrangements. They're going to say, why don't you sing it like this? Why don't you change this lick right here? That's a good producer. Now, some producers would say this is songwriting, and they expect a percentage of the musical composition copyright. Others would say, no, that's just me being a producer. But you want to make sure that that's clear before you get into the studio, because that is something we've dealt with, some really nasty litigation and almost litigation where basically it's pretty much broken up the band because nobody could pay to figure these things out, because they'd never talked about whether or not the producer was going to own any portion of the musical composition copyright. Our next, we're going to go a little bit more into works made for hire. I just kind of want to touch on this one. I feel like we kind of went into it already. So this is where the creator, the person that's actually creating the music or the work of art, has no ownership rights in the work, and maybe won't even be credited because they're doing it under their scope of employment with someone else who commissioned the work, essentially. So the work is prepared by an employee within the scope of the employment, or the work is specifically commissioned, and there's a written agreement stating work for hire. Anytime it's a work for hire, there has to be an agreement. It has to be in writing, because every transfer of copyright must be in writing. And the other thing is that this work made for hire has to fall into one of these categories. I know it's kind of a small list there. So a collective work, so a periodical issue, magazines, a motion picture or audiovisual work, a translation, a supplementary work, forewords, editorial notes, illustrations for a book, a compilation, the code in a program, instructional text, a test, answer material for a test, or an atlas. So if you notice, it specifically excludes a number of types of works. So such as, website, logos, advertising, photography, which I'm sure they're covering over on the other side there about the art and photography, and custom software. These types of works require an assignment agreement in order to transfer the copyright ownership.
And in the music context, we mainly see work for hire agreements in connection with using session musicians or, on occasion, producers. So if you're going into the studio and recording a particular song and you decide, what would sound really cool in this song? Like 8 seconds of horn. You probably wouldn't want that horn player who played 8 seconds to have ownership in that particular sound recording. So in the event you don't want that person to have ownership in the sound recording, you would hand that person a work for hire agreement stating that the work that they did, that from the inception, me as the band owns the copyright in that, not that particular session musician.
Yeah. And that's another thing for some of our studio clients. We have a work for hire agreement that they hand out to the session, like depending on the circumstance. If some of these people are going to get a split of the musical composition copyright, they've got the split sheet ready to go. Or if they're just going to be paid $200 to play a horn part, then they get the work for hire contract. So these are things that, especially if you're a studio owner, are things that you should have readily available, so that, first off, it's a good thing to have for your clients to come in. That will make you a lot more valuable, because obviously here in Austin, it's very competitive. And it's just a good practice to be in.
Yeah.
Because you don't want to be dragged into a lawsuit because you dealt with a client who didn't think about these things or didn't think they were important. How long does a copyright last? Once you register a copyright, which we're going to get into in a bit, how long does this copyright in that piece of art, that piece of music, how long does it last? So if it is a single author, so if it's me, I wrote a song, I own all the rights, it is my life, the life of the author, plus 70 years. What that means is that I'm able to transfer my right in the copyright to, by will, to somebody else. So when I pass away, I can give it to, my husband or my kids or whatever, whoever I want. If I don't like my family, I can give it to, the Queen of England. I don't care. Multiple authors, it's so a band that co-owns, it's the life of the last surviving author plus 70 years. So then these two other categories, a work for the work made for hire and anonymous works, it is 95 years from publication of the work or 120 years from the creation, whichever is shorter. We're going to get into why the definition of publication in just a minute. But the reason it's important is in terms of how long you have the copyright, how long it lasts. And after the copyright no longer is, after the life of the author in 70 years or whichever category we're in, the work goes into the public domain. I'm sure you guys have heard about this, and there's actually a website that you can go to search if a song is in the public domain, which is extremely helpful if you're trying to do a cover song or a Christmas album or anything like that. You can see which Christmas songs are in the public domain so that you don't have to worry about getting a license for them. So once something is in the public domain, you can use that work for free, public domain. If it is not in the public domain, that means you need to obtain a license. More on that later. And one thing to think about is let's say you have a public domain piece and you sample it or you cover it or something, you might be able to copyright that new work that you use that is based on the public domain song to the extent that there's new material added. However, it does not completely resurrect the song that's in the public domain. Other people can still use that main big public domain song, the original work there. Okay, so this published versus unpublished. So again, we calculate the life of the copyright for a work for hire, and when it comes into the public. Based on the publication date. So a work is published once it has been distributed to the public by sale or other transfer of ownership, by rental, lease, or lending. So basically, you've put your song out there to the public. Anybody in the public can find it. It's on Apple Music. It's on Spotify. You've been selling CDs. You've been giving out your digital download codes. That is when it has been published. When it's been given to the public, the community can access it. If it has not been distributed to the public, then the work is unpublished. Both published and unpublished works can be registered with the Copyright Office. So that's something to keep in mind. So now a little bit of kind of going back to some of the things we talked about in the beginning. What can be copyrighted? A song title. No, you can't copyright a song title. It's not enough. I'm sure you have seen multiple bands, multiple artists put out songs by the same name. That's not something you can copyright. A band name, no.
That's trademark.
That is trademark, exactly. That is your brand. That would be a trademark. That's for another day. A cover song is kind of a trick one. So a cover song can only be copyrighted it can only be copyrighted as a sound recording. So a cover song is a musical composition copyright that somebody else wants to cover that musical composition that they did not come up with and make another physical embodiment, another tangible form of that musical composition. So there can be multiple. One thing that I think is pretty clarifying is there can be multiple sound recording copyrights of the same musical
work.
Yes, the same underlying work, the same musical composition copyright. So that one's a trick question. Only the sound recording, the master recording, can be copyrighted.
We're going to get into copyright registration, and I first want to go over a few main misconceptions that I think are out there and that I hear on a regular basis. The first misconception isn't registration mandatory? It's not mandatory. I highly advise that you do it. Honestly, I implore that you register your works, but it's not mandatory. Copyright comes into existence once you have fixed your original work in a tangible medium of expression. So it's not mandatory, but please do it. The second misconception that I see pretty regularly is when I ask clients, have you registered your works? They say, well, yes, I have. I've mailed my works to myself. So
This drives me nuts.
Yeah, it
drives me completely
drives me nuts too. You don't have a registration when you have mailed your works to yourself. One thing I have noticed is in European countries, specifically countries that don't have their own copyright office, that people will do that as a means of evidence. But here, since the US has our own copyright office where you have people that will go in and review your application and send you a certificate, it's great. You're not protecting yourself by mailing your works to yourself.
Right. Especially, I think it's hilarious. Like, we've dealt with some copyright infringement cases. My firm also does litigation. And so we've dealt with a couple of litigation pieces. Anytime your copyright litigation is in federal court. So it's more expensive, it's a pain in the butt, and you don't want to be there. But it's hilarious because we'll get some people that will come in and they say, well, I can prove that mine was written first because I mailed it to myself, and it's got the postmark and all of this, and they hand it to me. They opened the letter. Like, really?
Yeah.
Okay, it would be great, but how do I know that how does anyone know that you didn't replace what was in that envelope with something else? That's what a judge would look at. That would be automatically thrown out as, legitimate evidence. So.
My personal favorite misconception is when people come in and say, oh, well, this particular work doesn't have a copyright notice on it, so that means that I can use it and do whatever I want with it. You cannot use it and do whatever you want with it. You still need to ask for permission. You don't have to use a copyright notice on your works. It's advisable that you do that, but just because something doesn't have a copyright notice next to it doesn't mean that you can just go ham and use it.
Yeah.
So let's talk about why you should register your copyrights. So first of all, by registering your copyrights, you're putting your work out there to the public. You're giving the public notice that you, as an artist, you wrote this song or you performed on this particular sound recording. What's great is there's a presumption of validity to a registration. So let's say you go to court for copyright infringement. You say, this person's infringing on my works. Here's my certificate. A court will presume that it's valid, and so the other party has to go in and rebut that presumption.
Exactly.
Also, too, if you have a registration, you can go to the U.S. Customs Service and record some stuff with them, and they will go and they will make sure that your works are protected from people internationally bootlegging your works. Also, too, kind of the two main points of why to register. First of all, in order to file a copyright infringement suit, you have to have a registration. And now the Supreme Court decided that that means you have to have your certificate in hand in order to file an infringement suit. Also, too, what's great about registering and registering timely, and when I say timely, I mean within 3 months of publication, so within 3 months of you releasing your music out there to commerce, or before the infringement occurs, a court can award you statutory damages, some court costs, and attorney's fees. Statutory damages are great because you don't have to go in and prove actual damages, which would be like trying to prove lost profits or how much money this other infringing party made from going out and exploiting your works. So that's great. And statutory damages could be from $200 up to $30,000 per infringement if the infringement is innocent. But if it's proven that the infringement is willful, a court can award up to $150,000 per infringement. Also, too, the court can award court costs and attorney's fees, which is a huge thing. I imagine you as someone who does litigation, that if you are a poor, broke artist and you can't afford to spend tens of thousands of dollars to litigate a copyright infringement case, an attorney would probably be a lot more willing to work with you on a contingency basis if they see you've registered timely and there's a possibility for statutory damages and the infringing party having to pay your attorney's fees.
Exactly. And the idea of actual damages, like let's say some big artist. And we actually had a case like this. We had an artist who had his baseline basically infringed on by a very large artist, and this artist put the song. The baseline was basically the entire. It was a rapper, so that was the entire backing track to his song, and he didn't credit him. He didn't anything. He didn't get a license. Nothing. And what ended up happening was because he had, our client hadn't actually registered it, and the large artist who had infringed on his work only had it for free download online, we couldn't prove, we had to tell our client, we've got a damages issue because you can't prove that this artist is actually making money off of it. It hasn't actually, we can't quantify this. So we ended up settling with the artist because it was extremely clear we were going to win the lawsuit. It's just we had a big hurdle we were going to have to get over because arguably our client maybe hadn't been damaged by it because this other artist hadn't made money off of it. It was just for free online.
Yeah, monetarily damaged.
Exactly, monetarily damaged. So.
Enforcement of copyrights. So the Copyright Office is basically a large office that holds a bunch of records. They aren't going to be enforcing your copyrights. It's up to you to enforce your copyrights. And so in the event someone infringes, the choice is yours. You could decide to do nothing. You could contact the infringing party and ask for credit. You could ask the infringing party for money. If the infringement occurs in connection with some sort of digital services platform like YouTube or one of those sorts of platforms, you could maybe send a takedown notice to the other party, or you could file an infringement suit. The choice is yours. It doesn't have to be negative, but yeah, it's completely your choice. And also understand that if you're wanting to use someone else's work, you need to ask for permission. And you need to understand the risk of not asking for permission, because if you don't, you could be sued for copyright infringement. And I don't think anyone wants to have to deal with that because it's going to be terrible and expensive and
very expensive.
And it's just too easy to go out and just ask for permission. A lot of the time people want their works to be heard, and it never hurts to just ask.
Especially now when all these musicians are posting, even well-known musicians posting their royalty statements online saying, well, look at what I'm getting paid. This is nothing. I think now of all times, people are more willing to license and collaborate with others. So there's really no excuse for not trying to get a license.
Exactly. We're going to kind of collectively talk about a typical client meeting. So we've had a couple of situations in which someone has come in and said, this person has stolen my music. And the first thing I tell people is, okay, let's calm down, let's parse this out, give me a background, let's see if there's actually a copyrightable work involved. And so we parse that out and determine if there is a copyrightable work involved. And then the very next question that I would ask is, have you registered your works with the Copyright Office? Mm-hmm. If the person answers no, I say, do that immediately, because in the event you do want to file an infringement suit, you have to have your certificate in hand. If the person,
that takes a while.
Yeah, it takes a while. I mean, it could be on average for me, I see about 8 to 9 months to get your certificate.
Yeah.
Granted, you can ask for the Copyright Office to expedite your registration, but it still will take about a month, and it's several $100s to do so. And then if the person that I'm talking to says, oh, yes, I have registered my works, then at that point, I then ask, so when did the infringement occur? If the infringement occurred after the person has registered their works, at that point I would say, that's great, let me refer you to someone I know that handles copyright infringement suits. Right. However, if the infringement occurred before the person registered their works, I would have to explain to them, okay, you have the uphill battle of trying to prove actual damages, and you aren't entitled to attorney's fees either, and so you're gonna have to pay probably out of pocket for your attorney's fees.
And most firms that do litigation are going to require a retainer up front, and for, if you're talking about an infringement suit in federal court, a lot of firms will require a $25,000 retainer or something, because once you push the litigation button, once someone pushes that litigation button, you are no longer in control of the things that you have to respond to. By law, you'll get served with discovery, and you have to respond within 30 days. And if they send you this obnoxious, completely ridiculous set of discovery, things you have to dig up, things that are really hard to find, things you might not know, you still have to respond. So you really have to take a lot of thought before thinking, I want to sue this person, I want to, because it's not fun. It's not fun.
Yeah, and expensive.
Yeah.
We are going to talk about how to register a work. I'm first going to speak about it pretty broadly and then narrow it down to the music context. So the first thing you are going to do is go to copyright.gov, that link right there. You can just even Google Copyright Office register my work, and just make sure you're not going to some third-party site. You're actually going to the Copyright Office website. And from there, you would create an account. And once you've created an account, then you'll be able to go to your account page, and on the left-hand side of your page, you'll see a link that says register a work. And so then you'll decide on the applicable application, fill in relevant information about the authors, copyright owners, whether or not the work was published, the publication date, if there is a publication date and the work's published. And then you pay filing fees, which are between $35 to $55 per application. And then at that point, once you're done with that, you can then upload the MP3 files or WAV files of your works to the application, or you can submit hard copies to the Copyright Office. And then you get to play the waiting game of 8 to 9 months before you receive your certificate.
And you hope that you did it correctly,
Yes.
So that you don't after 8 or 9 months, get a response saying, well, this song I noticed had multiple authors that weren't the same as the.
So one thing that is good by doing the application online, you can still submit paper applications. What's great about doing it online is in the event there's maybe some, you've maybe messed up on your application and the examiner notices that you've messed up, the examiner will shoot you an email and will say, can you clarify this for me? I think that you actually meant this. And then you can tell the examiner, oh yeah, you're right, I meant this. And then the examiner will go in and fix that problem for you.
Yeah.
So yeah, by doing it online too, it makes things a lot easier and allows for more of a free flow of information between you and the examiner in the event there is a problem. Registering your music. Just like I said before, you would go to your account page, register, and click on register new work. At that point, you would decide whether or not you are going to be registering your compositions, your recording, or both things. And the application form for the composition is the PA, Performing Arts form. For your master recording, it's the SR form. And what's great is, in the event you have the same authors and copyright owners of both the composition and the sound recording, you can file one SR application and it will cover both those things. Same goes for a collection of works that are published in a single unit, like an album. So going back to the mine and Andrea's band example, the Legals, let's say we wrote 10 songs together, and then we recorded those 10 songs, and they're put together on an album, and it's just us two. We can register all 10 of those compositions and all 10 of those recordings in one fell swoop on the SR application, meaning one $55 fee, as opposed to having to do everything one by one, which is very nice.
Yeah.
International registrations. So I am not going to really get into this very much because we don't do a lot of international work. But I do want to point out that there are quite a few countries that don't actually have a copyright office, so you wouldn't submit an application to them. Also, certain countries have different definitions of the right of the life of a copyright, and so it just kind of depends upon where you're planning to really exploit your works. And if you plan on, mainly exploiting your work, let's say in Germany, become familiar with German copyright law.
So copyright notices. Okay, so we mentioned it a little bit before that you don't have to include a copyright notice, but and anybody claiming a copyright can use one. You don't need to register first. You can just have written a work. Excuse me. However, it puts people on notice, everyone else on notice, that the work is protected, which is important. And to me, that's something that if you have that notice on it, that means you're taking it seriously and you're letting other people know, if I find out you're using this, I'm going to take it seriously. So what should it say? The word copyright, or this C with the, I hope it's big enough where you can see it. I'm sure you guys have seen this before, the C with the circle around it, or the P with the circle around it. I think people noticing the P with the circle around it is a little bit less frequent, but that means that the sound recording copyright is what they're claiming ownership of.
Phonorecord.
Yeah, a phonorecord, exactly. Year of publication and the name of the copyright owner. So my example here, I've got copyright 2019 Gwen and Andrea Slow Jams LLC. So that would put people on notice that whatever song it was, our slow jam is owned by us. So I'm going to get into licensing in a minute. So I want to kind of, dial back and talk about very basics. So again, copyrights are property, okay? It can be bought, it can be sold, it can be divided, it can be inherited. So any transfer must be in writing and has to be signed by the copyright owner. If you're going to assign your copyright to somebody else, it has to be in writing. A license is when you don't necessarily want to transfer the ownership of your copyright to someone else, you issue a license as the exclusive owner of a copyright. You remember she talked about the bundle of rights. You have all of those bundles of rights, and you can license permission for one of those or multiple ones of those. So A license is giving permission to use, to exploit the copyright without transferring the actual ownership. So this is a mechanical license, a synchronization license. And one thing I think is interesting is, or not interesting, it's there. The copyright law defines infringement as basically anybody who violates a copyright owner's exclusive rights is a copyright infringer and can be sued. So if you're going to do anything with somebody else's right in any of those bundle of rights, you need to get a license, or you need to make sure that they've actually transferred ownership of the copyright to you. In general, how do you obtain a license? So first off, you want to get as much information as possible on the song. The title, the writer, the publisher, the PRO. PRO is the public performing rights organization. The performance rights organization. We're talking about BMI, ASCAP, CSAC. You contact the appropriate PRO to get the name, the address, and the number of the publisher who controls the rights to that musical composition. You contact the publisher to get permission. And the type of permission that is required depends on the type of use that you're actually going to use. So if you're going to use it for a commercial versus a film, so a 30-second snippet in a commercial versus, the whole song is going to play in a film versus you're doing a cover song or whatever. Everything depends on the type of use that you're going to use of it. And then you follow up with the writing. You want it all in a signed contract or some sort of written agreement. And then also, if you're using, again, depending on the type of use, if you're using the actual sound recording, the actual master, because you're putting it in a commercial or something, you also have to get permission from the owner of that sound recording copyright. So not only the musical composition and the sound recording. So these are the general licensing things,
Yeah.
So next,
Well,
go for it.
one thing I do want to mention, when she says contact the applicable, when she says contact the performing rights organization, what's great is you can go to ASCAP or BMI's website and go to their registry, and you can type in a particular songwriter's name, artist name, song title, and you should be able to find information as to who the writers are and who the publishers are. And if there's a publisher, once you click on that information, it will give you either a phone number or an email address or both to that publisher. And in the event you're wanting to use a composition, whether it's in film, television, commercial, it's always best to go to that publisher with as much information as possible as to how you want to use it. So let's say there's a particular 30-minute clip that you want to use of that song. You need to, in your inquiry, tell that publisher, hey, I want to use it this much for this purpose. Because at that point, the publisher will have a better idea as to what to quote for the license fee.
Exactly. First, we're going to talk about mechanical licenses. I'm not going to get too in the weeds here and the different types of licenses and what kind of rights that you're required to obtain. But again, all of this boils back to the exclusive rights, remembering that bundle of rights that somebody as the creator either owns or, well, they own it, but they can either exercise themselves or grant the rights. They can authorize others to use those rights. So one of the rights was to reproduce the copyrighted work in copies or phonorecords. So as the owner of a musical composition, you have the first right. So you're the writer of the song. You came up with it in your brain. You have the intangible part. You have the first right to reproduce that musical composition as a sound recording. You have that first right to put the intangible into tangible. Okay, so once you kind of got that, after you've utilized that right, or you've assigned that right to somebody else, you've written the song and then you said, okay, Beyonce, you can record the sound recording of this song, which that would be a lot of money. That would be awesome. Then anyone can record that musical composition and basically make a cover of your song. And under the law, they're able to do this based on, for a specific amount of money, you get a compulsory license, is what it's called. So that party just needs to get a mechanical license from you as the copyright owner or whoever you've assigned the copyright to. In exchange, you'll receive mechanical royalties from the public performances. This is a lot to...
Yeah, and so basically, anytime a composition is reproduced as a sound recording on a physical product, you are entitled to 9.1 cents per song per record sold.
If it's 5 minutes or less.
Yeah, if it's 5 minutes or less. Same thing with permanent downloads. Now, when it comes to digital streaming, I am not going to even get into that because there's so many factors and the rate's changing and it's a mess. But just keep in mind that you give someone a mechanical license to reproduce one of your songs on as a sound recording, you're entitled to mechanical royalties.
Exactly. And it also makes it a little bit easier if you're wanting to cover a song, you at least know what you're going to be paying for it or what you should be paying for it. So how do you obtain a mechanical license? So how do you obtain a mechanical license? So your band wants to cover a song. So you can get the compulsory license like we talked about. And one place you can go, the first place you should check is Harry Fox Agency. You can just get online, and they've got this the song file system, I believe is what it's called. And you can search to see if the song is on Harry Fox. And if so, what you can do is you say, I'm going to make 500 physical copies of this album, and I'm going to put it on an album and make 500 physical copies and digital downloads of it, and it will spit out the price that you owe. And you pay it on the Harry Fox website, and then you've got your license right there. It's super awesome and super easy. So especially in situations like that, cover songs, you really have no excuse for not getting a license. The other way that you can get a license for, mechanical license is you can go directly to the owner of the musical composition copyright. The publisher, or if it's an individual that owns it, you can talk to the individual, and they own all of their publishing rights as well. You can go directly to them. If it's a friend of yours, for instance, maybe they'll give it to you for less than the statutory rate. So again, she mentioned that 9.1 cents per copy for songs that are 5 minutes or less. So if you're making 500 CDs, and the song's 5 minutes or less, then it's 500 times the 9.1 cents, and that's what you have to pay the original musical composition owner to get that license. Or it is 1.75 cents per minute or a fraction thereof for a copy of songs over 5 minutes. Again, these things get really convoluted, and we're not going to go into that. But next, kind of going to touch on samples. Get a license or do not sample. That's the safest route, I promise.
I've heard so many people say, oh, I can use 7 seconds or less of a song, and it's totally cool. It's not cool. You're still infringing. You need to get permission to use the sample.
There is a lot of crap online that makes up some legal something or other that is so not right. Any portion of anything that it comes from another song, if you use it and you don't get a license, it's infringement. Now, whether or not that person's going to come after you, that's a risk that you're going to take. So any unlicensed sampling is considered copyright infringement. So remember derivative works. She talked about derivative works. Using a sample of a previously recorded song in in a new song is a derivative work, and that original author has the right, one of those bundles of rights, one of the rights in the bundle of rights is to actually authorize the making of a derivative work. So that's where we come back to here, samples. You need to get permission if you're going to use a sample of something previously recorded. And this is often in contracts and colloquially referred to as clearing or getting clearance for your music. So again, with samples, you have to remember there are 2 copyrights involved. You don't only need to have permission from the owner of the musical composition, because you're making a copy of that. You're also making a copy of the sound recording, because you're actually copying the the physical thing that they recorded, their recording of that musical composition. So you need 2 licenses.
So one thing that I will kind of bring up is, so let's say, for example, someone comes into my office and says, hey, I want to sample this particular recording. I tell them, okay, figure out who the music publisher is or the person who controls the publishing, and figure out who the label is or the person who controls that master recording.
Yeah.
Then you tell those parties, this is what I plan to do with it. This is how much I plan on using of this particular song or recording that you own. This is the kind of genre of music I'm doing. This is how I plan on using it. And unlike mechanical licenses, the publishers do not have to grant you the license to use a sample.
Absolutely.
They can quote you any amount of money, same with the label, and or they can just outright deny you.
Yeah.
But one way of kind of getting around things is, let's say, for example, the publisher has said, okay, for $200, I can let you use 7 seconds of this composition. And let's say the label says, no, Beyonce recorded this and this is hers, so I'm quoting you $100,000. What you can do is you can record that 7 seconds of the composition yourself if you have permission from the publisher to do so.
Exactly. So you do a
so there is a little workaround there, but still, if you're planning on actually using the full recording, you're going to need permission from both the publisher and the label.
You notice this a lot in commercials. So someone will be hired to record a sound-alike. Or that's sort of getting into a different realm, but that's the idea, is that you can only get clearance from one of the two, so you make do. So last, sync licenses, or synchronization license. So this is, again, I mentioned it before, when you're trying to synchronize music in timed relation with an audiovisual images on film or videotape. So what that means is on a commercial or on, with a film, with anything.
Video game.
Yeah, a video game, exactly. Anything that involves some sort of picture, anything that's not just audio. So when you're dealing with that, you need a license for both the musical composition copyright and the sound recording copyrights. So you need to, again, just like in sampling, you need to get permission from both owners. There's no statutory rate for a sync license.
And when it comes to the actual sound recording, it's referred to as the master use license because you're using the master.
Exactly. Technically, the Copyright Office calls it the sound recording copyright, but in every contract you see, in it's the master. That's what we're talking about. We're talking about the master. Master equals sound recording. So we've got some fun scenarios to go through, and then you guys can get up and stretch and get a drink and all that good stuff. But we really appreciate you sitting here and listening to us, and this has been a lot of fun.
Yeah. So let's look at these 2 scenarios. Second scenario is on the next slide. So scenario 1, Taylor wrote the melody and David wrote the lyrics of a song. Taylor and David go into the studio. Taylor plays guitar, David sings, and Mike plays drums on the master recordings. So absent a written agreement, who owns the copyright in the composition? It would be Taylor and David, since they wrote the lyrics and the melody.
Exactly.
Now when it comes to the copyright in the sound recording, absent a written agreement, it would be Taylor, David, and Mike. And in the event that Taylor and David want to just own the copyright in that sound recording themselves, and they don't want Michael to have any ownership, they could present Mike with a work for hire agreement, and they could do that if they wanted.
Exactly.
So, scenario 2. David, Taylor, Samantha, and Alice write the lyrics and melody to a composition. Then David, Taylor, Alice, and Susan play on the master recording of the composition. There's no written agreements between the parties. So which copyright applications will they need to file with the Copyright Office? Well, in this case, since you have different parties that own the composition and different parties that own the sound recordings, each of those groups will need to file the PA form for the composition and the SR form for the sound recording.
Exactly. You can't do it all in one registration because authors have to be the same for everything.
Yes, the authors and the copyright claimants have to be the same.
And to get it to muddy it up a little bit more, let's say it was an album here in this second scenario. So David, Taylor, Samantha, and Alice wrote the lyrics and melody to all of of 9 out of the 10 songs, let's say, and then David, Taylor, Alice, and Susan wrote that other song. So then what you would have to do is you would have to have, for the 9 songs, you could have one,
You could file the Form PA for all the compositions.
and then you would have a separate PA form for
that one song
one
where
song.
the authors and the claimants aren't the same.
And then you would have a separate one for the sound recording copyright that had all 10 songs just for that one. So we would have 3 different forms rather than 2 different forms in that scenario.
Yeah,
So-
and that's provided that all of the same parties performed on all 10 of those recordings.
Exactly.
Yeah.
Exactly. So I guess long story short, it's never a bad thing to ask for help in dealing with these things because they can be very complicated, and one little change can really affect what you need to file or how you need to go about doing things. So it's never be afraid to ask for an attorney's help. I know that TALA, Texas Accountants and Lawyers for the Arts, who are putting this on today with the Awesome Music Foundation, they have really great resources, really great attorneys who are willing to assist in situations like this. And I would encourage you definitely to use their services and ask questions because there's a wealth of knowledge there, and they're available for you to use at any time.
One final question. When it comes to a song, how many copyrights are there?
Woohoo!
Yes, we
did
okay.
it. Yeah.
All right,
Awesome.
thank
Thank
you.
y'all
We
so much.
appreciate it.